I think we'll go ahead and get started. There are lunch bags coming, so feel free to eat more if you'd like when you eat them. But we're really excited to have Professor Dill here today. She is visiting us for a week from University of Oxford, where she's an Associate Professor of US Foreign Policy, also a Research Fellow at the Oxford Institute of Ethics, Law, and Armed Conflict. It focuses on the US military and collateral damage, and so we're excited to hear about current research, past research, and what she's working on now. So welcome.
Thank you so much.
And this is being recorded, so if you say something, it's going to be kept for posterity and put on the live website.
We're so promising. Well, thank you so much, and thank you for coming. I'm very delighted to be here. This talk is based on about 3 different research papers sort of put together, and it is interdisciplinary, drawing on legal, moral philosophy research, and empirical research. I will leave time for Q&A at the end, but if you have burning clarification questions while I talk, please feel free to just raise your hand and we can address them right there and then. So I'm very glad to be here to speak about the legal, moral, and military implications of collateral damage. Collateral damage is a really ugly word, a euphemism of sorts. So the question is, first and foremost, why would we use it at all? Well, if we want to have a comprehensive, multidisciplinary look at a phenomenon, we often find that different professional and scholarly communities have diverging language for that phenomenon. So while international lawyers, by and large, talk about incidental civilian casualties, a moral philosopher, for instance, might refer to it more as something like harm done to innocent bystanders. And military and strategic experts very often talk about collateral damage. Of course, we may find that these 3 things are actually not talking about the exact same phenomenon. And that divergence can itself tell us something about different preoccupations or angles that come with different disciplinary backgrounds on war. And we will in fact find that, you may all know that incidental civilian casualties are casualties that are unintended but foreseen, or they at least have to be foreseeable. Whereas from strategic perspective, collateral damage is often used to refer to simply all damage to the civilian sphere, regardless of the attacker's mental state. And often it is also used to refer to completely accidental, unforeseen civilian casualties. And as we will see in a moment, from a moral point of view, we are primarily not so much concerned only with the mental state of the attacker, but also the moral status of the person being harmed. And we will find that just as not all combatants are morally liable to being killed, not all civilians are, in fact, morally speaking, innocent bystanders. So where do we start? At the very bottom line, we are interested in gaining a better understanding of the human costs of war. And understanding and possibly taking into account that what counts as a cost, and this is the very crux of this theoretical endeavor, depends to some extent whether we take a moral, a legal, or a strategic perspective. So if my question to you is, whom should we spare in war? Who are we allowed to kill? Then from a moral, a legal, and a strategic perspective, the answer slightly differs. So what I want to do over the next 30 minutes or so is first map these divergences. The divergence of a civilian casualty, an innocent bystander, and from a strategic perspective, collateral damage. And I want to make 2 points, or sort of share with you 2 findings about these divergences. And the first is that the misalignment, or the at least partial misalignment between law and morality when it comes to the answer of whom are we allowed to kill in war, has both moral and legal benefits as well as costs. So this divergence is ambivalent from a moral and a legal perspective. Now then, if we bring back in the strategic question, we will find again that there's a partial divergence between whom we are allowed to kill from a legal perspective and the kind of human cost in killing in war that is strategically costly. And here it becomes tricky. This misalignment between the legal and the strategic answer to who we are allowed to kill in war is related to the divergence between law and morality. Because law depends for its strategic resonance partly on its alignment, on its expression of deeper moral principles. That may sound complicated, but I promise it'll become clear. So let's start with the easy part. the part that most of you are probably really intimately familiar with, which is the law. The customary rules for the conduct of hostilities, mostly spelled out in the first edition protocol, basically give us 3 principles to reckon with: distinction, necessity, and proportionality, in answering the question whom we are allowed to kill. And the first is the principle of distinction. Basically means that every release of firepower in war has to have an intended target of attack that is a military objective. That can be either a military object in the meaning of Article 52.2, or it can be a combatant. Don't worry about reading these principles. I wasn't quite sure how many of you have sort of completely memorized the Geneva Conventions, and how many of you have sort of only come across them. So basically, international humanitarian law protects civilians against intentional harming, but not against unintentional harming. So an attack against a military target is permissible, even if it is foreseen that civilians will die as an unintended side effect. Law then makes 2 demands about this incidental, unintended civilian harm. First, it has to be minimized and avoided as much as possible. This provision is often subsumed under the principle of precautions in attack, but in essence boils down to a prohibition on unnecessary civilian harm. Civilian harm that cannot be avoided, that is necessary in the pursuit of a military advantage, has to then also be commensurate or proportionate in the strict sense to the military advantage an attack pursues. That is the principle of proportionality. Crucially, from a legal perspective, all civilians are equally worthy of protection. They count as one civilian in the proportionality calculus, unless and for such time as they directly participate in hostilities. So a civilian, regardless of their conduct, their motives, their moral status, as long as that doesn't reach that threshold of direct participation in hostilities, they are immune from intentional harming. Right? So we only have really 2 categories: intentional targets of attack, combatants, and unintentional, and civilians who are protected against intentional harming. Right? There's no in-between category. Civilians, who deserve to be harmed or not, do not have a different status under international law. It's really sort of a dichotomized regulation. All of these permissions and restrictions that IHL sets forth equally apply to all belligerents in war. Right? So IHL is symmetrical in the sense that the permissions of battlefield conduct are entirely separated, independent from the political, the legal, and the moral context of the war. So it doesn't matter whether you are the one who started the war in violation of general international law, or whether you're legitimately defending yourself against an armed attack. It doesn't matter whether you have a politically expedient, urgent, important goal, or whether you're fighting a war of choice. It doesn't matter whether you have a morally just cause, or you are really the aggressor undermining the international order. Right? This is entirely insulated, the permissions and restrictions of conduct in war, from this context. Now, what if we radically change perspective and ask, what about morality? Right? What is the moral answer to the question of whom we should spare in war? From a moral point of view, we have to be concerned with people's rights, their individual rights, chiefly their right to life, which is a basic right in the sense that it's the precondition to your enjoyment of any other right. Right? So the question for killing in war then is, under what circumstances are we allowed to kill a person from a moral point of view? When do we not have the right to life, which protects us against killing? Well, there are basically 2 main situations that, under which it can be permissible to kill another human being from a moral perspective. And the first is the forfeiture of the right to life. So if I come at you with a baseball bat, right, clearly intending to kill you, and you have no other choice to defend yourself but to kill me in self-defense, then I have forfeited my right to life. I made myself liable to your defensive attack. And you killing me doesn't violate my right, right? It's a justified infringement of a right that I forfeited. In addition, on most counts, it can sometimes be permissible to kill someone who hasn't forfeited their right to life, who is an innocent bystander, who has done nothing to make themselves liable to attack, if this is the lesser moral evil. A lot of you may have come across trolley problem type scenarios, right, where we're being asked, can we redirect a trolley to kill 1 person in order to save 5? This is a classic lesser evil justification for killing, right? If we're warding off a great moral evil, sometimes it can be permissible to attack and to kill a person, to deprive them of their right to life, even though they haven't forfeited it, which would be a justified rights infringement. What does this mean for killing in war? Well, it means we have to be concerned with the individual moral status of the person we are killing, right? We have to ask, what is the civilian actually doing? Liability to harm, the forfeiture of a moral right, isn't the same as having an assigned legal status, right? We actually want to know, are you contributing to an unjustified threat that makes you liable to harm? Now, we know that not all combatants actually contribute to the fighting, right? We know that from research that some are too frightened, too scared, too shell-shocked to ever release their weapon. So not all combatants are morally liable to being killed. Right? Not all civilians are innocent bystanders either, which is sort of harder to swallow. Right? If you think about the contribution to a threat or to the war in terms of directness, then there's sort of a rough correlation between combatants making more direct contributions to the war than civilians. Right? After all, most combatants will fight, most civilians won't fight. But the moral significance of a threat or a contribution to a threat isn't exhaustively grasped with its directness. Right? Now imagine the civilian political leader who voted for the unjust war and who could vote to stop it. Right? Or the civilian nuclear weapons expert who is helping to build a nuclear weapon to be used in war. Or the really talented radio broadcasting host who whips up frenzy against the enemy. All of these people are, legally speaking, civilians, but they make more significant contributions to the war than the lowly conscripted foot soldier, the military cook, the logistics officer. Nonetheless, they are not legitimate targets of attack from a legal point of view. And this becomes even more glaring if you think, well, what is the most effective way of warding off this unjust threat, of winning this war against this unjust enemy? It is probably not to kill a lot of military cooks and foot soldiers, right? It may well be to attack the civilian politician. Nonetheless, from a legal point of view, they remain immune from attack. So the first significant divergence between a moral and a legal answer to the question of whom we must spare lies in this dichotomized civilian combatant distinction of law on the one hand, and the much more complex question about the individual moral status of a person and their liability to harm. The second divergence lies in the symmetry of international humanitarian law, right? So morality is asymmetrical. If I come at you with a baseball bat, right, and in the last moment you draw a knife to defend yourself against my attack, then I don't get to kill you in self-defense. You don't forfeit your right to life because your threat is justified by my prior threat. So morality retains the asymmetry between an attacker and a defender, and only one side is permitted, morally speaking, to use force. So that means that only really in an unjust war does a contribution by a combatant, for instance, to the war make them liable to harm, morally speaking. And only really in a just war, a war that pursues a morally important aim, am I allowed to kill innocent bystanders, right? Because only the pursuit of a just cause might mean that killing someone as a side effect is a moral lesser evil, right? So morality is asymmetrical. International humanitarian law is not. It gives the same permissions regardless of whether or not you're pursuing a worthy or an unworthy aim. So these divergences are fairly well appreciated. The question is, what follows, right? Should we simply then say, well, that means law needs to change? That may be politically difficult, but come on, it diverges from morality. No, the story is more complex because this divergence has costs and benefits, and it has both legal and moral costs and legal and moral benefits, right? The very obvious moral cost is that international humanitarian law and compliance with the law doesn't vouchsafe the moral permissibility of conduct in war, right? So not every time somebody is killed in compliance with international humanitarian law does that not amount to an infringement of their right to life, right? It may well be morally unjustified conduct. That is a cost in moral terms. You could say, well, we don't want to go too far into jurisprudence, but maybe the point of law isn't to reflect morality, so this is surely not a legal problem. But even from a legal perspective, there's a cost to this divergence, and it lies in a lack of action guidance in the principle of proportionality that stems from this divergence. So what is proportionality? It is the demand to weigh two ostensibly quite dissimilar things, right? Military advantage and civilian casualties. Now, for the moral principle of proportionality, right, what we do is we weigh moral evil and moral good, right? That's harm we cause to innocent bystanders and the moral importance of achieving our aim. We can convert both of those into the common metric of moral value, right? From a legal point of view, we can't do that. We don't have that option, right? Because international humanitarian law demands that you do not resort to considerations of the war's overall aims, its moral context, its political urgency, when determining conduct in war. That includes the principle of proportionality. So the only metric we really have to determine the weight of a military advantage is progress towards military victory. Now, can we convert civilian casualties into progress or regress towards military victory? Not on IHL's own terms. Because IHL declares civilians to be immune from attack on the assumption that their death is not militarily useful, right? That it is militarily neutral, that there are side effects, that it's incidental, if anything, right? So we cannot really say how do civilian casualties convert into progress towards military victory, but that's the only metric on the law's own terms that we have to determine the weight of a military advantage. And what results from that is really a difficulty of figuring out what is proportionate incidental harm from a legal perspective, right? I've conducted interviews with military experts, across many years, and there's almost no convergence in what people think, experts think that looks like, right? There's now some forthcoming experimental work by some colleagues in Israel who did an experimental survey where they asked military experts, what do you think is proportionate? And again, the divergence is absolutely staggering, right? And that is a cost for the law, because the point of law is to guide action, right? It is to actually tell you what to do.
Just clarification, the student Israel, was that asking Israeli or general military personnel?
So they did several surveys, actually, and the expert survey, the first they did, was not just military experts, but international. I got that too, interestingly. So they asked moral people, they asked lawyers. And I think they followed this up with convenient samples of the general public, which is, if I recall this correctly, only marginally worse at converging on what that looks like. So there we have a legal and immoral cost to this divergence, right? Which would say, well, yeah, then we definitely should change law, right? But now imagine what if law actually more closely tracked moral principles, right? If it attempted to give as close as possible the same answer to the question of who you're allowed to kill and who you must spare in war as morality. Again, there's a very obvious moral cost, which would, imagine you're addressing a belligerent by saying you are only allowed to kill if you have a just war, right? So at least one side in each war has absolutely no reason to be swayed to consider law, to comply with international law, or more likely both sides think their war is just, right? And then avail themselves of the licensing that law affords the just belligerent. This very likely, we can't prove this, right? But it is very likely and intuitively compelling that the consequences of this would be much worse in moral terms. That we would simply have a whole host of unjust belligerents who fight as if they had a morally important just goal. Right? Now imagine the soldier on the battlefield if law addressed them with the notion of you can kill as many innocent bystanders as is proportionate to your exalted and extremely important moral aim. Right? This is very unlikely to be an effective restraint, because the soldier is subjected to the state's rhetoric of, this is our important and just war. No state ever has started a war and said, sorry, it's unfortunately an unjust war. Right? So this is just not how law works. Again, you say, well, this is a moral consequentialist argument. What about the law? Are there legal costs or legal benefits to this divergence? And indeed, there again is a legal benefit for law not tracking morality more closely, which lies again in action guidance. And this time, the principle of distinction. It's really difficult already on the battlefield, the modern battlefield, to distinguish civilians from combatants, right? Now imagine IHL said, that's not what you're supposed to do, right? But you can kill people that responsibly contribute to the unjust threat your enemy poses. The epistemic burden, right, to figuring out what that means on the battlefield is incredibly high. So the soldier that law addresses this way is either paralyzed by inaction, will never do anything because in case of doubt, you probably shouldn't shoot someone, or more likely, again, they will feel licensed to kill people because on the other end of an AK-47, people look liable, right, even though they may not be liable. So again, there's a moral and a legal benefit to laws being diverging from the underlying moral principles about killing. Okay, let's bring in strategy. What, from a strategic point of view, counts as a cost of war that we must avoid? You could say, well, the point, surely, of war is to kill people, right? Unfortunately. If we try and, bracket our moral impetus, our normative intuitions, surely we must simply come to the conclusion that the point of a war is to kill people, and this is not really a cost. Maybe civilian casualties don't make sense, legally, militarily speaking, but surely they're not costly either. Well, that's actually not true, right? It's very difficult for us to suppress our moral commitments, but if we try, right, if we looked at this purely from a strategic military point of view, there are still two ways in which civilian casualties are costly, or killing in war can be costly, not just civilian casualties. And they're basically in the sense that they can undermine the support for a war at home, and that they can undermine the achievement of a war's political goals. Let me explain both of those. So we have a long, and ever sort of more extensive body of literature in social sciences that shows that US military casualties undermine support for a war at home. Right? There are certain factors that can mitigate this effect, but there's a long-standing sort of quantitative work showing that the higher the US casualties in war are, the lower support for the war at home. So human costs, perceived human costs, negatively affect war support. We don't know whether this is true for civilian casualties, right? Whether the US public in the same way cares about civilian casualties. The preliminary work that we have suggests that they definitely worry more about US casualties, right? But there's some work indicating that they're not completely neutral either. Now, certain belligerents don't have to care about this, right? But if you're a democracy at war, right, ultimately you can only wage a war that is supported, that has a modicum of support in the population at home. So if it is then true that civilian casualties undercut war support, then they can be strategically costly. And we at least want to know more about the conditions under which they are, in fact, strategically costly in the sense that they undermine war support. To know the second way, or understand the second way in which killing in war can be strategically costly, we have to take a sort of detour and ask, what are the kinds of political aims that states pursue with military force in the 21st century? There's, again, a trend, a fairly long and coming trend, in which wars for the purposes of permanent shifts in territory decline, and wars rise in prevalence that actually have complex political end states without any commitment on the part of the belligerent winning the war to stay on the territory, right? Now imagine if you have a political goal, right, related to how a society organizes themselves on a territory, like regime change, related to their religion, their toleration of non-state actors, and you don't actually intend to stick on that territory forever, then the achievement of your political war aims hinges on the perception and the support for that aim in the local population in the theater of war. So what we have is a rise to prominence of war aims that are ultimately perception dependent. That if they enjoy absolutely no support in the local population, their achievement cannot be but ephemeral, right? In the sense that you might get to install your regime for a little while, but if the population isn't on board, that will not be the long-term outcome of your war, right? So this rise to prominence of perception-dependent political war aims basically means that we have to care from a strategic point of view what the population in the theater of war thinks. And there's something deeply paradoxical, right, about having an end that depends on perceived legitimacy and choosing as a means force, violence, right, which almost as of necessity will harm the audience you're trying to address or convince of something, right? And this is a phenomenon fairly well studied that, in fact, indeed, as you might expect, civilian populations in theaters of war punish belligerents that harm them. So the first point here, this shouldn't say collateral damage, because these studies are basically about intentional and indiscriminate violence, right? But again, there's a very solid body of literature that has shown that belligerents that harm civilian populations suffer strategically. It taints their political goals. It undermines their military effectiveness. We now have a slightly more recent body of work on counterinsurgency specifically, which suggests that also actually collateral damage, unintended killing, can taint a belligerent's war aims, and it can make the insurgency more effective. And the argument or the assumption associated with this is that civilian populations punish the belligerent that causes collateral damage by then providing support and information to the insurgency. Right? We don't actually know this because most of these studies don't investigate the attitudes of civilian populations in theaters of war directly, but they make inferences about beliefs, right? Between saying, look here, civilian casualties go up, the insurgency increases in effectiveness. That is probably because the civilian population punished the coalition in Afghanistan for collateral damage. So to sum this up, right, we basically, the strategic implications of killing in war and the notion that killing in war can be costly is related to popular attitudes, to the perception of killing in war as costly, and the notion that it is a cost that then warrants withdrawal of war support or withdrawal of support and punishment of a belligerent and tainting of their political goals. And we have two different audiences whose attitudes we are interested in, in light of these costs, and one is the population at home, particularly in democratic belligerents, and the other one is the population in the theater of war. Now, where it gets interesting is that this very realization on the part of military and political decision makers, right, that the human costs of war are strategic costs, right, has fueled the legalization of warfare in certain belligerent theaters. It has given belligerents a reason to comply with international humanitarian law or to institutionalize resort to international humanitarian law. It's not exactly the same as compliance, but to draw on law. Why? Well, one assumption I have encountered again and again in interviews with military practitioners is the notion that killing in war that is legal is less likely to undercut war support, is somehow more acceptable, both at home and in the theater of war. And interestingly enough, the US counterinsurgency manual actually spells out this assumption, right? It says we have a collateral damage dilemma, which means that in order for military force to be effective, you just unfortunately cannot avoid killing some civilians. But every time you do, you taint your political aims. Every time you do, you increase support for the insurgency. What do we do with this dilemma? It's actually remarkably short on guidance, but it says obey international law. Right? Kill in war in line with the principles of distinction, proportionality, and necessity, and the unspoken assumption that that is then less likely to undercut support. You may ask why, right? Is it realistic to assume that an Afghan civilian who has lost a loved one cares that this was in compliance with international humanitarian law? Is it realistic to think that an American citizen who sees that there are civilian casualties or even US casualties in an overseas theater wonders, well, is that legal or not? Well, if it's legal, it's okay. Right? Most people will not know what is legal and what isn't in the first place, right? They can't make that judgment for themselves. And whenever there is actually killing in war that comes to the court of public opinion through newspapers or media commentary, usually the legality is contested anyway. Right? So how should that be? Why should there be this correlation between killing in war that complies with law and killing in war that somehow avoids having the strategic costs associated with it? Well, the assumption that I actually encountered and sort of teased out in these interviews is that law expresses prior beliefs about what is right and wrong, which is not entirely unreasonable, right? Why do we have international law ever? It is because there was probably some sort of consensus about what is appropriate and what isn't. So the unspoken assumption isn't so much that people care about legality per se, right? But that killing in war that is legal is perceived as less unacceptable or more acceptable because the categories we draw on to delineate acceptable from unacceptable killing are the categories that law draws on to delineate permissible from impermissible killing. Now, while that is not totally unreasonable, it is also not at all clear that that is true, right? Because law is a political compromise. It's often a sort of lowest common denominator, and we already know that there's at least one set of principles about right and wrong about killing in war that law doesn't perfectly express, which is moral principles, right? So what my current research is basically doing empirically is trying to test these assumptions. It's trying to test the resonance of legal principles in popular attitudes. And what I'm going to do in my remaining time is basically highlight the results of two projects, one on the population in the United States and one on the population in Afghanistan. And relying on very different methods and having slightly different implications, but basically trying to gauge the extent to which their attitudes towards killing in war reflect legal principles. And the first project is a project that is co-authored with Dr. Livia Schubiger from the LSE Government Department. And we basically rely on an experimental survey with US adult citizens, 3,000, and a roughly representative sample. And what we did is we basically gave them an experiment that was meant to gauge what logic their own attitudes towards killing in war follow, right? Based on what criteria do they decide whether killing in war is acceptable and whether it should affect their support for a war. And so we have two experimental components. The first is a vignette experiment. We basically randomly assigned these 3,000 people into three groups. In one group, the United States is facing a fictional terrorist adversary that is about to launch an armed attack. So this is a war that is legal, it's prima facie morally justified, and it's definitely politically urgent. We don't say any of these things, right? We just tell them this is the war. In the second group, it's the same setup, but there's intelligence suggesting there's no threat of an armed attack. And the third is a control group, where we simply say, look, here's this fictional adversary, the United States is fighting a war against them. And then the second part of the experiment is what we call a conjoint experiment, where we're basically giving people pairs of targets of attack, and we're asking them to choose which one they would rather attack. And we asked them to rate their support for these attacks. And these attacks have randomly varying attributes that track legal and moral prescriptions. So this is what this looks like. This is one of the conjoins. So we have 4 target attributes, right? And each attribute varies on these levels. So the goal of the attack, this is obviously what matters from a legal point of view, right? So if legal principles resonate with popular attitudes, we would very much expect that people consistently choose a military power plant over a civilian power plant, and that they consistently choose a combatant over a member of the civilian government, right? We picked a radio broadcasting station because it's a very interesting, contested object in terms of whether or not it's actually a military objective under Article 52.2, right? The prosecutor in the prosecutor's report on the legality of the US bombing in Operation Allied Force against Yugoslavia sort of rendered a very, not exactly a non-leaked, but it could be legal, right? And the United States has been tempted consistently in its military operations to target means of spreading propaganda. And so we included this basically, I would argue it is not a military objective under Article 52.2, particularly with the reasoning we gave, which is to undercut propaganda. But we included it partly because we wanted to see where people stand. Now, from a legal perspective, we would also expect them to minimize civilian casualties, right, in line with the principle of necessity. And crucially, we would not expect them to actually care about the contribution that civilians make to the war, which varies here, because we very deliberately vary this below the threshold of direct participation in hostilities. However, it is morally relevant, right? It is very much a morally relevant variation in contribution, responsible contribution to the war. So this is one plot showing the results, and basically what you see here, the average marginal component effects. So what they say is basically the change in percentage that a target will be chosen or not chosen if a target contains a certain attribute level versus a baseline level. So for instance, a target that had 2,000 expected civilian casualties, right? It was 30% less likely to be chosen than a target that had 0 to 2 civilian casualties. So what you see here in essence, this is the 95% confidence interval, and the standard error is clustered by respondent because each respondent had 5 choices. So what you basically see here is that people act remarkably in line with legal prescriptions, right? In the middle, you see the target of attack. They consistently prefer the military objective and the combatant, and they kind of like them to equal extents, right, over the civilian object and the civilian person. And the radio broadcasting station kind of hovers in between, right? They also, in line with legal principles, minimize expected civilian casualties, but they do so regardless of the moral status of the civilian, which is the second from the top, which has non-statistically significant effect on the likelihood of whether or not a target will be chosen, and there's no interaction between them either. Remember the vignette, right, the prime? What we would very much expect is that these effects move from a moral point of view when you are in a just and an unjust war, right? But from a legal point of view, they shouldn't move, right? Because IHL is independent from the moral and legal context of the war, and they don't move, right? We haven't done all the data analysis yet, and the interactions effect there are different ways of parsing them out, but everything currently points towards the fact that the vignette doesn't affect the marginal component treatment effects of these individual attributes. And it doesn't do so even though when respondents were asked to rate the targets, they consistently rate lower all targets in the unjust war. So they remained aware. We also asked them, did you think this was, this war is, did you support this war? And they don't support the unjust war, and they don't support targeting in the unjust war. But that doesn't affect how they weigh different categories and considerations. So they act remarkably like lawyers, and remarkably not like moral philosophers. This is slightly different in the second project I did. They're not perfectly comparable, partly because they rely on vastly different methods, but I also did ask slightly different things. This is a project that relies on 87 semi-structured interviews with Afghan civilians in Kabul in 2015. And they all were chosen because they had been displaced due to harm that they attributed to coalition forces. I'm happy to say more about the method and the selection of interviewees. All of this is really tricky from a social science point of view. But basically, they had their stories fell into 4 different categories of what had displaced them, and they all had either lost family members, close family members, or had been themselves injured, often both, in these attacks. And what I basically did is I first let them tell these stories without any interference or interruption, simply asking what happened, and then asked them structured questions about intentionality, necessity, the perceived military value. And the point here is to find whether the perception of the attack circumstances and aims, right, is systematically associated with whether or not they perceive the attack as legitimate and whether or not they blame their attacker. And of course, the expectation from a legal point of view would be that an attack that's perceived as unintentional is less likely to be perceived as legitimate. And an attack that is perceived as the civilian harm was avoidable should be more blameworthy and less legitimate. So this is one of the results, which is basically basically associating the initial narratives that people presented before they knew what the story was about, right, what the research is about, to their answer to the question of whether or not they thought they had been harmed intentionally. And somewhat good news for the coalition, 80% of the people I talked to thought they had not been harmed intentionally. Right? I'm happy to talk more about how we tried to make them understand what we meant by intention. It's not straightforward either. But basically, a vast majority didn't think it was the point of the attack to harm them. And there were very strong association between them and the two narratives that I had identified in their initial stories. And one basically I called military pragmatism, right? Which is the notion, well, why did this happen to you? Well, this is war, right? No one distributes sweets in a war, is what a lot of people said. This is simply what happens in war. And the other one is sort of a self-defense type narrative. There was a story that was very common where the Taliban were hiding in a civilian compound and shoot at a convoy, a coalition convoy, and the coalition then calls in an airstrike and the whole compound is flattened. Right? And quite interestingly, among those who thought they were harmed intentionally, completely different narratives prevailed. Right? In a similar sort of situation, they wouldn't say, well, this is self-defense, but they would feel like they were unfairly punished, like collective punishment. Right? They think we're just all Taliban. They think we're helping the Taliban. Or even the notion that Americans think it's intrinsically useful to kill civilians or that they like it. Right? So character flaws of the attacker. A similar association emerged with blame. So this is not a quantitative project, so it's a little bit misleading to plot it this way, but it's quite striking how often or how different the picture or the attribution of blame was among respondents or among interviewees who thought of themselves as unintentional side effect victims. Right? So about 61% of them said, yes, I blame the attacker. And it's close to 90% among those who thought they were harmed intentionally. So you just look at this sort of two on the left. The others are unsure. This is not super striking, right? And we would, of course, expect most people say, yeah, I blame the person who killed a part of my family. But then, if I have time, I'm going to show you this one. When asked, do you blame anybody else alongside the attacker? I was really surprised, that 41 out of 43, this is like 97% or so, of those who thought they had been harmed unintentionally said, yeah, I also blame the Taliban or this insurgent group, the other side, right? Whereas that was 50-50 for people who thought they were intentionally harmed. And even slightly more striking, everyone who had said initially, I don't blame the attacker, and who said that they were not intentionally attacked, entirely blamed the other side, right? So this is clearly pointing towards the resonance of the legal distinction between intentional and unintentional harm in the attitudes of these civilians, right? That they do perceive, the principle according to which one is permissible and one is impermissible resonates in their attitudes, as this is clearly one of the categories that they draw on to make sense of what happened to them. And the same or similar result occurred for necessity, right? The perception of whether or not the coalition could have avoided harming you, but not for proportionality. So it was simply not intelligible exactly to people what the military value of the attack should have been and how that could possibly be related to the civilian harm. Right? It's not quite exactly the same as I found with military expert, but it is a similar non-resonance. Most of them simply hadn't thought about the military importance of the attack and the circumstances. But most of them actually did draw on a proportionality type argument, but one that evoked a lesser evil justification. By and large, none of the people I interviewed thought the United States or the coalition had a legitimate overall aim. But a lot of them volunteered to say, well, but if someone is bringing peace and stability to Afghanistan, if someone was fighting for a proper aim, I would be ready to sacrifice my sons. Right? In fact, I also asked them to fill in a trolley scenario adjusted to be plausible in Helmand. And yes, civilians in this theater of war, civilians who had themselves experienced harm at the hand of a belligerent, were open to a lesser evil justification for killing in war. So where does this basically leave us? Here, what we find, right, is that basically the ability of IHL, right, to mitigate the strategic costliness of killing in war depends on its underlying convergence with moral principles, because it seems to be moral principles rather than legal principles that inform the civilians' judgments, right? So IHL has the power to reduce the perceived inacceptability of casualties in war, right? This may sound cynical, but it is true for the two principles that express morally meaningful restraints on conduct, which is distinction and necessity, right? But proportionality, in virtue of its divergence from this underlying moral principles, doesn't have that power. Law here doesn't align with a strategic answer to the question of whom we should kill in war, and it doesn't align in the same way as it doesn't align with the moral answer to the question of whom we should kill in war. And I think I leave it at that so that we have some time for discussions. That was the conclusion. Yes?
My question has to do with the first study you referenced about Americans' attitudes towards war.
Yeah.
And I think an interesting question I have is whether the fact that the Afghans that you surveyed in the second one bear the cost of war themselves might make it more morally relevant to that versus a survey of 3,000 Americans, how many of them have been to a combat zone before?
Few, yeah, we asked.
And so how do you think that informed it? And is there some effort to get perceptions of U.S. military members themselves?
So it's an excellent question. I usually don't present these two projects together, and I don't want them to appear as if they spoke to each other, because not just in virtue of the method, but it's a completely different audience, right? And I would very much expect that the having experienced harm yourself informs your attitudes. On some level, I framed the project about Afghan civilians as sort of a least likely case, right? It's the hardest audience for any moral principle, any kind of legal distinction to make a difference. Because it would be very understandable that you simply reacted by blaming the attacker and thinking illegitimate an attack that destroyed your life, right? So the amount of differentiation I found and the fact that moral principles clearly seem to inform these judgments, these reactions, I found quite remarkable. It's much less remarkable that Americans who sit in the comfort of their home, and fill in a survey have differentiated opinions, which they should have, right? We didn't find, I think we have to go back to analyzing this. We didn't oversample on military expertise, but we did ask people whether they had any combat expertise. And we also asked them whether they knew law. It doesn't look like these things affected their views, but in order to systematically study how military people feel about this, I would want to run a different survey. And it's in fact one of the things my collaborator and I are hoping to do in the future, to run this with people who have either combat experience or at least military training. Does that answer the question? Yeah.
Just a naive question, but where does international humanitarian law come from? Somebody voted in, or is it a bunch of professors who made it up?
So it's actually an important question.
Why do we call it law at all? Rather than just law.
So it is descended from battlefield conventions, right? So there's an alternative theory of morality in war called sort of conventional just war theory, which is quite in line with international humanitarian law. But the kinds of legal principles that I draw on here, they are codified treaty law. So they are mostly spelled out in the first additional protocol to the Geneva Conventions. So their legality, right, their compliance pull formally stems from consent of the states that have acceded to them. And the United States hasn't. So to the extent that the United States is bound by these principles because they are considered customary international law. And those that I draw on are, by and large, considered customary international law.
UK part of that?
Yes. Any other questions? Yeah?
As it's harder, potentially, in new warfare to determine who a direct participant in hostility is, how do you feel that changes the moral calculation? And do you think that the law has adequately caught up to that?
So does it change the moral calculation if someone is a direct participant in hostilities?
If it's increasingly difficult to tell who a direct participant in hostility is.
Yeah, I wonder whether it ever really was straightforward to tell, right? I think we overestimate sort of, this sort of idea of the ideal type of war on a battlefield with two armies and everyone else is nicely insulated. That's more an ideal type than a historical reality ever. But I read this study with great interest, and that the fact that, people don't perceive themselves as either direct participants or not, everyone is kind of involved when there's a war going on, shows that there's a certain artificiality to legal categories. Almost unavoidably so, right? But I think it matters both whether they track morally relevant categories and it matters whether they track people's intuitions, partly because that's the only hope in the world they have to be complied with, right? So direct participation in hostilities is somewhat modeled on morally relevant categories in that it tries to track your conduct as well as your mental state, right? Your intention and do you know what you're doing. So it is actually closer to what a moral answer to the question would be, when should a civilian lose immunity from attack, than the sort of dichotomized distinction, combatant or civilian, right? So it's not a perfect tracking of moral principles, but I think it does have moral resonance. And it's not something I've worked on, but I think the bottom line of the study was that it doesn't really resonate with civilians in war zones because, everyone's kind of implicated or involved. Does that answer the question?
Yeah.
This is less of a question, more just a comment. What I'm wondering about with that big study that you had is how much it's influenced by what people picture the terrorist group as.
Mm-hmm.
So in this day and age,
I don't have this.
It's Islamic terrorists, ISIS, and Boko Haram to some extent are much more harsh on civilians to have a lot more suicide bombings. I'm just wondering how much that would influence perception compared to 5 years ago, maybe.
So in an experiment like this, you always face a trade-off between what you would call external and internal validity, right? So external validity, and for a scenario to be realistic, you ideally would want to tell them this is Boko Haram, or this is, because then you tap into someone's prior ideas about the world. But that is then problematically from an internal validity point, because then we don't know whether people's views are about their logic towards killing in war or about Boko Haram, right? So we very consciously chose a fictional adversary because we are interested in prying apart moral and legal principles. We did, of course, ask, did people have associations with our scenario? I usually have a slide to this effect, but I don't in this case. But I think I remember that about 9% thought the country in which the terrorists operate is North Korea, and that was the highest individual country to get. Then the next one was, I think, Afghanistan, but they're all single digits. So that's good, right? This is as close as you can get in an experiment like that to sort of try and find a neutral baseline. Not quite so good as was the question of who do you think these terrorists are, or do they resemble any terrorist group you know? And there again, we didn't get any particular terrorist group, but I think around 20% thought they were Islamic fundamentalists. I hope not the same as thought it was North Korea, but it's definitely, there was more of an association, and this is not entirely surprising, right? It's probably unavoidable because most people associate terrorism with Islamic fundamentalism, and we gave them options, right? They could have picked other things, and not everyone picked Islamic fundamentalists, but there was an association with that. Yeah.
On the study about the assessment of morality by your survey population, did you ask them at all about the weapon choice or means of killing, and as opposed to just estimating casualties for them? Is there any sort of inherent morality associated with certain choices of weapons and how discriminate they can be?
So in this project, we did another conjoint, but this target conjoint clearly is imitating a pre-planned air campaign, right? This is also why we don't actually give them US casualties in this, because it would simply be unrealistic that you have that. I'm doing a completely separate project where we're asking about nuclear weapons, and we're trying to figure out whether people feel differently. And there's actually one of the articles I cited has done some prior work on this, Press et al. About, do people feel like, all things considered, is it worse to use a nuclear weapon? And by and large, people think so, yes. But then there are also people who think, all things considered, it's better to use a nuclear weapon because you always get additional benefits. It's sort of a slightly different question. I mean, we're trying to also get at people's views about chemical weapons versus nuclear weapons, but this is a pre-experiment stage, so I don't have results on that yet.
Do you think the perception of these civil victims would have changed if they had been attacked, only by airstrikes? In terms of, because I guess even if that doesn't change the legal considerations, it does change. I would assume more.
Yeah.
Right? Or the fact that we live in Kabul, for example, they had much more contact with the U.S. forces than in an area where it was under control of the Taliban, for example. So using these parameters.
I would expect both of these things to matter. So they were all displaced from Helmand and Kandahar. So what had happened to them had happened in Helmand and Kandahar. But it's true that they had been in Kabul for varying amounts of time, and therefore had some more exposure to US troops than they probably had previously. I'm very sure that very sure as you can be, that it matters whether it's a ground or an air assault, partly because this self-defense narrative was so strong. And so if someone is, that seems to be your best bet in terms of getting away with collateral damage, if I put it crudely and cynically, is the notion that you had no choice but to defend yourself, right? There's potentially a cultural component that this is a particularly strong narrative in Afghanistan. I can't know this, right? But that definitely did matter. And the notion that harm was avoidable, that there wasn't even any need, no one was under attack, that is the worst, right? This is when civilians really level all out blame. It's this sort of method, small n interview method, allows you to sort of draw out a lot of richness, but it doesn't allow you to control for things, right? So therefore, I can't really sort of isolate the effect of air versus ground. But the narratives very much suggest that this matter in virtue of the association of self-defense versus you could have just tried harder, right? So yeah. Yeah.
Just to go on that, I spent this lot of research regarding people's mindsets, say with airplane accidents versus car accidents.
Sorry, say that again?
Airplane crashes versus car crashes.
Uh-huh.
People feel a lot more safe if they think they have a chance, they have an amount of control, even if the statistics make them far more likely to be in danger in that circumstance. And I suspect if you talk about survivors, their perception may vary depending on whether they thought that the person had a fighting chance, that the person had a chance to escape or fight.
You mean the civilian casualty had a chance to escape? I'm not sure. I mean, this comes back a little bit to the earlier question of does the weapon choice matters, right? So this is one of the intuitions people have about robotics and automated killing, that people find it worse because it's more like being killed by an animal and there's no way because they're so effective. It's not the kind of experiment that can test that, but I share your sort of prima facie intuition that this probably matters. I mean, it seemed from the stories that I was told that it wasn't by and large the fact that, civilians in this sort of context don't have a fighting chance, mostly, right? So it mattered a little bit whether, there were indirect artillery fire versus direct shooting and airstrikes. So the mode in which people had been harmed mattered, but mostly in virtue of then triggering, a very certain attribution of intent or some uncertainty regarding intent, or a very clear self-defense frame versus no, absolutely no self-defense frame, right? So these things are sort of intercorrelated / polluted in this story. Yeah?
I just want to ask again, something related about the absence of moral judgment in that first study. Thinking from a targeting perspective, and maybe you should ask this back to the legal folks here, how relevant is the affiliation of the incidentals to the casualty and their moral blameworthiness just for being the combatant or the target relevant towards making those decisions and accepting that kind of level?
Not at all, from a legal perspective, right? So your affiliation, your sympathy for the terrorists, nothing of that matters. Your conduct doesn't matter unless it meets the criteria of direct participation in hostilities, which it didn't here, right? And to some extent, this seems morally problematic, right? So much so that the most recent US Law of War Manual actually makes some rather worrying steps towards differentiating between civilians who kind of deserve to be killed and those who do, in the context of human shields. They also resurrect this idea that if you are, as a civilian in a munitions factory, you're taking risks, right? This is technically not legally relevant, right? There is no such thing as a quasi-combatant anymore. There is a combatant or a civilian. And a civilian who isn't immune from attack is then an intentional target of attack. It's not a civilian that took some risks and therefore deserves less protection or counts less in the proportionality calculus. But the appeal of that argument, right, is so strong that even, I'm not sure who wrote the US Law of War Manual, but it was presumably a lawyer, right, that they get tempted by this kind of reasoning. Yeah, I don't know whether...
Sorry, just sort of similar to that. Referring to the law manual, there's this, we talked a little bit about DPH, but there's this sort of newly introduced idea of the revolving door,
right,
wherein someone
Not in this moment, yeah.
Exactly. Is there anyone else besides lawyers in the State Department or the Defense Department who are sort of buying into this theory? Has it
That this is problematic?
No. It's sort of, yeah, exactly. Sort of share this evolving door concern, or is this something that's sort of uniquely American?
I mean, as often with these interpretive controversies in IHL, the US position is the most forcefully articulated.
Right.
But I think this is a strategic concern writ large, right? Because, and the idea of the continuous combat function is supposed to take care of this to some extent. And again, the argument underlying this is just not how wars work, right? And if you have non-state actors fighting, which you now have in, like, I don't know, 90%, I mean, a lot of wars aren't state on state, then your predominant pool of people whom to target are targetable in virtue of DPH, not in virtue of their combatant status, and then you must care about how this plays out in reality. So I think that it's not a sort of ludicrous concern to say, why, will we ever even be able to militarily effectively wage a war like this if this is the standard? It's also, there's also, fairness is the wrong term, but why are combatants always targetable even if they're at home in bed, right? And someone who is fighting in a war, and simply because they happen to fight for a non-state actor, they can sort of withdraw from that status. Is that even fair, right? And this sort of matters not because law needs to necessarily express categories like that, but it relies on its resonance for its compliance, right? So I think the concern isn't completely without merit. But it is also, I mean, this is part of why this study, didn't meet with the kind of, the kind of support that it ideally would have needed to really clarify the law.
Do you have any sense of commenting what the actual ratio is in a conflict like Afghanistan of combatant versus non-combatant fatalities? The reason I ask this is because I remember reading an article in the New York Times where Obama said there are hardly any collateral people, hardly any collateral killings. And then I met a guy in the physics department over there talking from Pakistan, and he said, well, the average Pakistani would say they're killing maybe 100 civilians for every targeted person they kill. And I don't see how we can assess the moral status of, say, the United States and Afghanistan if we have no idea at all what the ratio is. The ratio is supposed to be significant.
So this is a problem for law, for morality, for any kind of judgment, right? You have your moral principle, and to know what it means in a particular case, you need to have reasonably certain facts about what's happening on the ground, right? So this is as much a problem for law as it is for morality, as it is for a strategic assessment of what's going on in Afghanistan. I don't know, exactly what the position is, except that there is an intense level of contestation, not just about numbers per se, but also about who counts as who. There was a time when the United States counted militarily aged males in certain regions as combatants or insurgents, right? Which helps you in your count. That drives up the combatant count and down the civilian count. That then was contested and came under a lot of scrutiny, so arguably that's not what's still happening. But the status of each individual person is contestable, and in the kind of intelligence situation that you're operating, it remains contestable, right? Which is why these factors routinely diverge these numbers by a factor of 10, right? And then, what you could say, well, why are we even asking then, right? If we have no chance to figure out what was or wasn't legal. I think there are two different concerns. On the one hand, to say, what does the law mean, right? How should we interpret it? What does a good faith interpretation look like in the first instance? And then say, okay, was that one, right? Is that legal? Is it illegal? The contestability of casualty numbers is only one thing that cramps your style if you want to make an argument about what was or wasn't legal. The other one is intentionality, right? How do we ex post facto determine whether a target was intentional or unintentional, whether it was reasonably foreseeable or not? So IHL is, in its justiciability, quite limited. And the contestability of casualty numbers in war zones is only one of the many factors that undercuts its justiciability.
It doesn't provide any actual numbers, right? Like you kill
it doesn't, no.
one civilian for every 5 targets. It's just some kind of what we can call reasonable.
Excessive is the standard, right? It shouldn't be excessive, and this is what I said earlier, right? The fact that the legal proportionality calculus is divorced from the moral and political context makes it really difficult, I actually argue in one of my papers, impossible for the average human mind to determine what is and isn't excessive, right? Simply because military value or progress towards military victory isn't a metric that immediately translates into how many civilian casualties, right? So I think it's not a action guiding legal rule.
So you haven't actually tried to study what people morally think is the proper number, the ratio number, like you with the trolley problem?
So I haven't, but people have studied this. On peacetime killing, this is quite widely, trolley problems have always fascinated people, right? And there's now at least one experimental study that tries to get people's number intuitions, and the only bottom line that anyone can say about this is that they diverge, right? Very, very widely. And it's not clear what the minimum convergence we expect from a legal principle, right? How much reasonable room for disagreement should law allow or shouldn't allow, but it really looks like if there is such a thing as a principle, legal principle that doesn't work, that doesn't guide action, that doesn't constrain intuitions, then proportionality is it.
Ms. Dill, thank you so much.
Thank you for coming. Thank you.